compliance law, specifically your code of conduct. This regulates exactly what you should do on deals, what you shouldn't do on deals. The things I'm going to focus on here is definitely mandates. Who gets a mandate signed every single time they do a deal with a client? Very few of us. There are a couple, very, very few of us. Mandates are vitally important. Do you guys do verbal lease agreements? No. Why are you doing verbal mandates? I know a lot of the time owners don't necessarily want to sign mandate agreements because they think that there's a power of attorney incorporated in the documents. So perhaps a nice way of getting around it is calling your mandate agreement something different. Call it like an authority to lease. That's fine. You can do that. There's no problem with doing so. Yeah, nice way of getting around it. But mandate agreements are vitally important. And the reason why I always come back to this is there's certain relationships in the property sector, and I can tell you now the most volatile relationship I've seen is not between landlord and tenant. It's between agent and landlord when things go wrong. It's very, very volatile. Because at the end of the day, what a landlord sort of thinks is that because he's getting an agent involved, he's guaranteed rental for the full lease period, which isn't the case. It's not like agents have a crystal ball that they go and look at and say, oh, this tenant's not going to pay this month. It doesn't happen. Sometimes things just go very, very wrong. So with mandates specifically, between which two parties is a lease agreement? Landlord and tenant. Do you see here that we didn't mention agent at all? Because an agent's got nothing to do with the lease agreement. It's a landlord and tenant relationship that it's regulating, isn't it? So what regulates the relationship between a landlord and an agent? And if you don't have a written mandate in place, what's that? Verbal agreement. Not a great idea, is it? You didn't see this, but me and this gentleman in front actually had a discussion during the break, and he told me he's going to pay me 10,000 Rand for the session. Anybody who backs me up gets 5 grand, I'm serious. Do you see that? How difficult is it to prove verbal terms in a contract? It's almost impossible. No, you said the commission is 2%. No, I didn't. I said it was 8%. No, you didn't. It's very difficult. But it's also nice to know that a mandate agreement, if it's written, does not just protect an agent, doesn't just protect the landlord. It protects both parties, just like what a lease agreement does. If you don't have a written mandate in place, like I said, you've got a very iffy little thing that you're busy doing. Also, a lot of contracts or lease agreements will stipulate that the agent is the effective cause and there's the specific commission that's payable to the agency on signature of the lease agreement or on extension of the lease agreement, whatever it might be. That is not your mandate agreement. That's proof that you entered into a mandate agreement, but that's not your mandate agreement. Because remember, which two parties is in a lease? Landlord and tenant. Agent doesn't have an involvement over there. It's exactly the same as writing like a surety agreement in your lease agreement. It doesn't work. You need a separate document. So please keep that in mind when we go through these provisions. So let's turn right over to Code of Conduct Rule 3, Estate Agent Mandates. No estate agent shall offer any immovable property for sale, to let, or negotiate in connection therewith, unless he has been given a mandate to do so by the seller or lessor of the property or his duly authorized agent. Simple as that. I mean, you've got a mandate. It doesn't say here it's got to be written or whatever it might be. Let's quickly have a look at 3.3. No estate agent shall accept a sole mandate or the extension of the period of an existing sole mandate unless all the terms of such mandate are in writing and signed by the client. Interesting. Sole mandates, what are those? You're probably thinking sales, huh? Sole mandates. What's a management mandate? What's it? It's a sole mandate, isn't it? Because I as agent have sole right to do what? Manage the property. It's not an open mandate. It's not like another agency can just step in at any time and take over and do whatever it wants unless your mandate's been cancelled. But you've got a sole mandate in place. So technically speaking, in terms of your code of conduct, you need to have written mandates if you're doing management property. Just pointing it out. Please focus on that. I would love to see just sole mandates everywhere and just written mandates everywhere because it is going to regulate the relationships between the parties a lot better. I believe. If you're going to have a look at the TPN mandate as well, we've got these rights and responsibilities and duties that the party should perform. We're updating the documents now as well. That's going to be less inclusive, but if you'd like to make it more inclusive, it's going to work as well. So you can go and fill certain things in. It's going to be very nice. Have a look out for that. Here's another little bit of a issue, and I don't know how strict they are currently at the EAAB regarding this specific provision, but at 3.3.2, so no agent shall accept a sole mandate or the extension of the period of an existing sole mandate unless the expiry date of the mandate, which shall be expressed as a calendar date. Interesting once again. So if you've got a rental mandate in place, if you don't have a written document, you've obviously got a verbal document that could well be on a month-to-month basis. Nobody knows because we don't know what the terms are. Or it could be for how long the lease agreement is. We don't know. But if you've got a written sole mandate agreement in place, your end date must be stipulated as a calendar date. It can't just say at the end of the lease term. It's got to be a specific calendar date. Remember, those contracts are completely separate, your lease agreement and your mandate. Completely two separate things. Lots of agents, and I have this very, very often, and I always have to sort of seek a declarator over the telephone of who's your client. Think about it quickly. Lots of estate agents refer to the tenants as their clients, don't they? The client just did this. The client just drove in with his X5. The client's going to sign the lease agreement. Client just paid the rental and the deposit. They refer to the tenant as their client. Whereas, if you're doing normal mandates in every single situation where you're leasing out a property on behalf of a landlord, who's your client? Landlord. Just imagine the situation. I apologize for the very bad example here, but I never did divorces, but I'm sure this will be a situation. If you go to, or you need to get a divorce, and you go to an attorney, and your attorney keeps referring to your new ex-spouse as the client, how happy are you going to be? Excellent attorney, I'm going to get that guy again. It doesn't work. Think about it that way. It's not a tri-party relationship that you've got here. The landlord is appointing you as somebody to do something. So remember that. Client, landlord, always. So let's go further into this. We can skip 3.4. We can go over to 3.5. Nice important one. So no estate agent shall accept a sole mandate which also confers upon him a power of attorney to act on behalf of the person conferring the mandate unless the intention and effect of such power of attorney is fully explained in the document embodying the sole mandate. Interesting. Who signs lease agreements on behalf of the owners? I'm not going to out you, promise. It happens. Do you have powers of attorney in place every single time that says you may sign the document on behalf of the owner? Every single time you've got to have it. Remember, you know, it's like stepping into the shoes of the contracting party. The owner's giving you permission to sign a legally binding document on his behalf. It's exactly the same as opening a bank account on behalf of the owner. Do you think he'd allow you to do that without a very specific power of attorney? It's vitally important. Powers of attorneys, you can get into quite a lot of trouble for doing things like entering into lease agreements on behalf of somebody when he hasn't given you specific power of attorney to do so. For instance, just imagine this. Your owner's sitting overseas in Germany. No, let's even say this. Closer to home. He's sitting in Cape Town. You give him a call and say, hi, listen, the tenants just signed the lease agreement. The owner says, don't worry, you can sign it on my behalf. Just sign it and send it through to me. You sign the document. The owner says, I didn't give you permission. Why are you signing documents on my behalf? Happens a lot. Protect yourself. Also in this provision, it specifically states that either mandates and powers of attorney need to be completely separate, or they can be contained in the same document, but the terms have to be incredibly specific. So if you're doing powers of attorneys, you say, I may sign this lease agreement on behalf of the owner on this date with this tenant. That's specific enough. But please go and protect yourselves as agents. Get powers of attorney if you're signing on behalf of clients. I know sometimes it's very, very difficult saying, your owner is sitting overseas or whatever it might be. Get those things in place. Good. Just protect yourself, please. 3.8, I had this situation. Knowingly or negligently make a material misrepresentation concerning the likely market value or rental income of immovable property. Seen that one go very, very awry at the EAAB. Then the estate agent's duty to disclose relevant facts at 4. An estate agent shall convey to a purchaser or lessee all facts concerning such property as are within his personal knowledge and which are or could be material to a prospective purchaser or lessee thereof. I had a situation now that an estate agent called me and said, hi, listen here, there are these material defects on the property that they're going to sell. Do I have to tell it? Do I have to say it? It's vitally important. That deal can get kicked out, it can be voided completely, and who's sitting with the baked potato? Agent. So remember these things in the code of conduct. Then we can move over. 5.3. Greg, you can agree with me here, but attorneys sometimes do this quite a lot. Claim to be an expert or to have specialized knowledge in respect of an estate agency service if in fact he is not such an expert or does not have such special knowledge. I think at the beginning when you're an attorney and you need to get work in, you're like, oh, divorces, yes, I've done those. I know exactly how those work. Or evictions, whatever it might be. If you do something like this and you purport to be an expert in something, you actually give yourself a higher standard of care. So if you do like any sort of negligent act, or whatever it might be, you will be held liable. You're held up to a much higher standard of care if you call yourself an expert on something, or a specialist in some certain field. So keep that in mind. This question I did ask in the last session at 5.8, but who gets their notices stolen? Your boards. Or they get taken out of the ground and put somewhere else. My word. Okay, so at 5.8, no estate agent shall affix any board or notice to such immovable property indicating that such property is for sale to let, yada, yada, yada. The seller or lessor has given him written consent to do so, and the estate agent concerned, in fact, has a mandate. So you need to get written consent to place adverts. Doesn't usually happen that a person takes you on about something like this. I've seen it happen in a body corporate sectional title situation, because in terms of the Sectional Titles Act, a estate agent needs to get permission from the trustees to go and place adverts. And I've seen them get very irate with people just placing adverts on the property. So perhaps not a bad way to go and do it. Just speak to one of the trustees before you go and do something like that. Then we can switch over. There's not a lot more of the estate agency code of conduct except for 6.2.1. An estate agent shall explain to every prospective party to any written offer or contract negotiated or procured by him in his capacity as an estate agent prior to signature thereof by such party, while very long-winded, the meaning and consequences of the material provisions of such contract or offer. Interesting. So you need to explain to your tenants and your landlords exactly what the material provisions of the contract mean. Every deal. Interesting in terms of the code of conduct. The one thing that I always tell clients is if you're uncertain, the TPN has a very nice way of dealing with this, but you've also got my number and the office line. So if you've got an issue and you need to explain something, you can tell the tenant to contact us. We don't have an issue with that. But what we've got on our lease agreements, very nice. On the right-hand side, you've seen that. It says something like Ask TPN. You can go and click on that and it opens up a wiki page that explains the entire provision to the person. Nice way of doing it. So you can go and tell them, listen, you just go and click on the wiki pages if you're uncertain of how to do it. But material provision explanations, nice way of doing it. And then we can just have a quick squiz at Rule 10, confidentiality by the estate agent. And this is regarding, once again, POPI. There's already confidentiality clauses in a lot of the pieces of legislation that we're currently having a look at. POPI is just going to extend this thing into making it way more regulatory based.